Hello and welcome to Legal Thinking with myself, Ed Wootton.
And me, Liam Pep.
As some of you may have noticed, if you've been following us on social media, we're talking a lot about the family court system, separation, divorce, mediation, arbitration, all this kind of thing, and the need to think outside the box sometimes with some of the pressures that are on the system at the moment.
So continuing with that theme, in today's episode we speak to Nick Marson and Jayne Martins. Nick was a barrister in Bristol for 30 years and then in 2005 became a circuit judge specialising in family work in Hampshire and then Bristol, and he retired in 2020. And he's now an arbitrator with St John's Chambers in Bristol. Jayne Martins is a solicitor and partner in the family team at RWK Goodman, as well as a mediator who's been practicing since 2008. In this episode, we discuss the differences between mediation and arbitration. We discuss if no-fault divorce has had any bearings on the pressures currently being put on the court system, and we also talk about the effect that the cost of living crisis is also having on the family courts.
Yeah, and if you want to kind of read around the subject before listening to the podcast or after, you do you, just make sure to go to rwkgoodman.com/outside the box, all one word.
Let's roll tape. So I'll start off with a question for you, Jayne, if that's okay. Can you talk a little bit about some of the stresses that are on the family courts and the system at the moment?
Yeah, so there's been a backlog with the courts for some time. I mean, it was already pre-COVID getting pretty clogged up, but with COVID hitting, it's just exacerbated the problem. So court dates are often being pushed back. Just accessing the court itself is taking some time. We've transitioned onto a new online portal, which, as with any new online system, has its problems and has its downfalls. So there are some delays that are happening now in the court system. Everyone is working incredibly hard, and there's no lack of desire to want to be able to provide that service. But unfortunately, there's been a perfect storm with cuts to the funding, the COVID hitting, and people not getting back into the buildings themselves, which has really led to a bit of a backlog.
And what's your perspective on this, Nick? Do you view the same?
Yeah, I think Jayne's quite right. I even before COVID, there was a huge backlog, and of course the sort of work with the children work which I was doing was dominated then, and even more so now, by public law work, care proceedings, that sort of thing. And I think all of those backlogs have got much worse, so that private law children work, which is the other area that arbitration, for instance, is allowed to deal with, there's a huge amount of work that's just not getting processed at the moment by the court. And again, I emphasise it's nobody's fault. It's certainly not the fault of the judges or the practitioners. If you turn up at court and you look at the lists, some days you are amazed. I mean, I was in speaking to a couple of people the other day, and one judge had 24 cases on his list.
Wow. So a few people have suggested mediation and arbitration being a way of getting us out of this mess. But Nick, for our recent report Outside the Box, you expressed some concern around this. Do you want to explain a little bit more?
I think I view children mediation and arbitration as a really vital tool in the toolkit for everybody dealing with cases, both from a philosophical point of view, because I think it's easier, better, more user-friendly. I don't know how you want to characterise it, than the court system. Because by the time we got to the court system, the minefields are laid out and the machine guns are planted on both sides because it's a contest. No matter how we try to pretend it isn't. And in mediation, of course, that's not the case. And even in arbitration, the impetus is towards settlement, towards taking the pain away, towards not litigating the minor things, and making it a much more user-friendly experience, tailoring it to the clients as well. So I think the only problem there is with this is, of course, that it is a service which requires the clients to fund it. There is no public funding for this, as there is in most family work. And so there is a slight problem with the possibility of a two-tier legal system in effect.
And Jayne, do you agree with Nick's analysis here? Is mediation and arbitration the way that it's going to go?
I do agree with Nick. I think it's really helpful to have these as additional tools. We've got mediation that can work in family situations, and arbitration as well, which should also be used and is possibly underused at the moment. But mediation's very helpful and very successful, but it is voluntary, and it needs to continue to be voluntary because it is you're trying to encourage two people that are in conflict to work together to find an outcome. And it depends on the level of conflict that is involved as to whether that's going to be successful. So it's not going to work in every case where there's domestic violence, for example, or where there's some significant mental health issues. Mediation is not going to be the answer. And arbitration possibly could, but would have its own difficulties. And I think there is a real problem about it being funded by the public. They're going to have to pay for these resources and pay for these services. So that needs to be taken into account and can cause some problems. And it's why the court system is still very much needed, and a service that is providing a service to its users. So these should very much be looked at as an addition rather than instead of. But absolutely, the use of mediation and arbitration is really key to sorting out a lot of the cases that are now clogging up the courts.
Yeah, if you think of it as a road down which each family travels after the breakup, sometimes they don't need to travel very far because they agree with each other, the parents. And over children and over money. Sometimes they have to travel the whole distance to the court. But all of these other things, like mediation and arbitration, are turnings in the roadway which give them an opportunity to consider the case and to come to an end of the case before you reach that last stop, the courts.
This is an open question. I'm not trying to drive you down any route, and you can feel free to disagree with me. But are there any practical problems with arbitration and mediation as a solution to take the burden off the courts? So, for example, is there enough arbitrators and mediators? And similarly, is there a concern that as more people turn to this method of resolution, that there'll be even less kind of public funding for the courts if kind of it looks like the tide is turning towards arbitration and mediation? I realise it's a big question, but Nick, could we get your thoughts on that?
Yeah, it is a big question. What the financial circumstances of the country are such that the government is looking to save money, and we all understand that. But if it seizes on mediation and arbitration as a reason for cutting down the court, the money and funding available for the courts, available for judges, available for the sheer running of the court as well, then that's a really, really bad idea, because that situation will just make it worse. This isn't instead of, it's as well as, and it gives the right sort of, it gives you a full spectrum of remedies to deal with all the different sorts of cases, different sorts of personalities that are involved, the different sorts of problems that are involved.
Jayne, is there anything else you'd like to add on that point?
I mean, I agree. I think there are quite a few mediators. They changed the system a few years ago where mediators had to be accredited, which was actually the right thing to do because it's a very particular kind of role that a mediator undertakes, and it's important that they have appropriate qualifications to be able to undertake that task. So it became a lot more onerous for people to become mediators. So there are less of them around, but I think there are probably enough to be able to support that. And it's kind of a self-fulfilling prophecy. If you have a bigger demand for people wanting to attend mediation, then more people will train and qualify as mediators. Arbitrators, I doubt there probably are enough, actually, if there was a surge in demand. I'm not sure
I think mediation
how readily...
is about 10 to 15 years in advance of arbitration at the moment. It's much more bedded in, isn't it, Jane?
It is, absolutely. And it's been around for a very long time. So there are people that have been doing mediation for years, decades, but less so for arbitration, which I think has meant there's been less cases and then less people training to become one. So,
and I mean, to be fair, it's only since the mid noughties that we've been able to use arbitration in family cases at all.
Yeah, absolutely.
If we can just take a step back a bit, sorry, we probably should have explained this a little bit earlier on, but if you just want to explain what mediation and arbitration are and what the differences are between the two of them.
Do you want to do mediation, Jane, and I'll do arbitration?
Great, yes. So mediation is a service for families that are separating, usually, and it enables people to come together with an independent mediator who has not met either of them outside of the process. And through discussions with the mediator, they work towards reaching their own outcome for their own set of issues. And that is through a series of meetings directly with a mediator. It's voluntary, so nobody is forced to do it, and it's voluntary for the mediator as well. So the mediator has to identify that the case is suitable for mediation. But the mediator, who remains impartial throughout and isn't there to judge either of them, will help them identify what the issues might be and look at what the solutions and what the options are with them so that they are informed and able to make their own decisions.
Yeah, so the key difference in arbitration is that they are not able to make a decision because they both have usually perfectly sensible, reasonable arguments to put forward. And in those circumstances, they can't agree, but they jointly appoint somebody to make a decision for them. And that's what an arbitrator is. He cuts the Gordian knot and says, you're right, you're wrong, or whatever it happens to be. So it's much more of a dispute process, whereas in mediation, it's the parties bringing it to an end themselves. But having said that, because it's a tailor-made process for that particular case, it is much more user-friendly, in my view at least, than just going into the one-size-fits-all court situation.
Fab, thank you very much. So back to the questions. Jane, I'll stick with you for a second. Does no-fault divorce have any bearing here in terms of the stress that's been put on the court system?
I don't think it does. Well, I say that. So no-fault divorce has come in from April this year, and it's a really key and positive change to the divorce law in that right from the get-go, when people separate, they're not being forced into a position to assign blame to either one of them when looking to separate and divorce, which can take the heat out of things when you're having that initial discussion with your client. We don't need to know why people are separating or why people are divorcing. They are just allowed to separate and divorce on the basis of the marriage irretrievably broken down, and that's really the end of that discussion. So it's really useful, and I think it takes the stress out of that element of the separation. But along with that, the process has changed, and it's now a far longer process because it's felt that it was sort of public policy to have a cooling off period built into that. So it's now at least 6 to 7 months before you're going to get a final order within the divorce. And for people that want to resolve their finances and issues very quickly, that can add a bit of delay, but that doesn't really impact the court process or how people are accessing the court.
Okay,
so I think on the whole, actually, it's a really positive change.
And Nick, what are your predictions for the future in terms of the stress on the court and mediation and arbitration? So especially as the cost of living crisis is really beginning to bite, how do you see things going?
Well, I'm so old that I've been a lawyer through 2 recessions, and on both of them, unfortunately, recession, financial pressures in particular, but all the other sorts of pressures which come with that, leads to the breakdown of more relationships. So I think, sadly, the cost of living crisis will just make things worse because living is more difficult, and living as a couple and living as a family is more difficult. Financial worries are corrosive, and they lead to breakdowns of relationships and breakdown in traumatic circumstances. A lot of the time, a relationship separates and the parties recognize it's just run out of steam. And in those circumstances, mediation it works very well. Sometimes the parties can even agree without mediation. But where you have a traumatic breakdown, it is much more difficult for mediation to succeed. I see arbitration then as a situation where the parties have both got strong views. They need them decided, but they need them decided, if possible, with keeping the lid on. What we do not want is the sort of disputes that we are seeing in the courts at the moment, where it starts off as an argument about where you're going to pick up the kids on a Saturday morning for contact, and ends up with an argument about absolutely everything. And unfortunately, that happens where these cases come to court. A lot of the time, they get worse because they are being decided in an adversarial atmosphere, even though the lawyers, the judges, everybody within the courts are trying to talk people down. By the very nature of a court dispute, it becomes more traumatic. So, number one, I think that whilst we have more poverty, more financial need, more financial worry, it'll lead to more pressure on relationships. More pressure on relationships will lead to more pressure on the ways to bring relationships to an end, which includes the court. But if we have mediation and arbitration as well, at least there are some other options to go to.
You mentioned there about kind of arguing over child arrangements. For couples who are doing that, is family court the only option?
Family court, mediation, arbitration, family court.
Okay.
There are certain sorts of case that you can't mediate, domestic violence, for instance. Then there are other sorts of cases where you're not allowed to arbitrate either, and those are cases where there's issues of child harm, significant harm to the child. The arbitrator is not allowed to deal with those. But there are a lot of cases where the parties just disagree about how much time they should each be spending with the kids. They disagree about where the children should live, where they should go to school, whether they should live in Cardiff or should they be allowed to move to Birmingham. All that sort of thing. And that's the sort of thing where if mediation can't sort it out, arbitration can. And I think is a really good weapon in the armoury to do that.
And finally, I think, Nick, you've basically answered this, but I'll go over to Jayne for this question. We touch upon the issue of domestic abuse in our report, Outside the Box. Jayne, is it difficult to settle this kind of relationship breakdown outside of the family court?
I think it's difficult, but not impossible. I think often in situations where you have domestic abuse, usually the relationship has broken down and the parties have separated and living separately and apart. And if that's the case, it's still possible to mediate because you've removed the stress factor that was putting them in that relationship that was the source of the domestic violence. But that's not to say in all cases it's suitable to have mediation where there's domestic violence, but it's not an absolute bar as long as there were safety measures in place and both parties felt that they were safe and able to remain safe before, during and after the process. But it is one of the factors that mediators have to take into account. And it may mean where there has been domestic violence, particularly if they are still living in the same house, that it's not suitable because you could potentially be inflaming situations and then leaving them to go home together in a hostile situation.
Of course.
So it's a factor that needs to be taken into account, but it's not an absolute bar.
Jayne and Nick, thank you very much for your time.
Thank you.
Thank you for listening to Legal Thinking, and thank you to our guests for joining us on today's podcast. If you want to find out more about the topic that was discussed today, make sure to have a look in the show notes where we'll have linked everything up.
And you can find all of the back episodes of Legal Thinking in your podcast provider of choice, and you can also subscribe and follow us on there too. And as always, make sure you leave us a 5-star review on a podcast provider of choice, as that helps other people find us. Thank you very much for listening, and we'll see you next time.
Bye-bye.